International Criminal Court was set up in 2002 to bring to justice perpetrators of genocide, war crimes, crimes against humanity, and the
Taking
crime
a closer
of
look at a critical report from the U.S. State Department. It found the Israeli military may have used weapons consistent with international law, but acknowledges there isn't enough information to prove it. The report points to the high number of civilian casualties in Gaza.
From a legal perspective, how do governments go about trying to negotiate the release of these hostages? What concessions could be offered, even though we've been told in this case none were?
It is critical
How would it work?
in this moment that my office and all parts of the court continue to conduct our work with full independence and impartiality. And I insist to impede, to intimidate, or to improperly influence the officials of this court cease immediately.
We have the general image that what the law is and the meaning of the word international seems self-evident. Yet when we put these two words together, we find ourselves faced with other questions that stem our understanding of their meanings. In worse democracies, the word law immediately conjures up images of legislatures, police, and courts that create law, enforce it, and punish those who violate it. International brings up images of not only of the United Nations, but also of wide-ranging global differences, economics, cultural, and political relations. In this age of equality and mutual collaboration and peaceful coexistence, no state can have an independent and secluded existence. All the states are related to one another in a variety of ways. Every state has its relations with other states of the world. The laws which regulate the dealings of the states with one another are called international laws. Definitions of international law. Gilchrist maintains that international law is a body of rules which civilized states observe in their dealings with each other. These rules being enforced by each particular state according to its own moral standard or convenience. Professor T.J. Lawrence defines international law as the rules which determine the conduct of the general body of civilized states and their mutual dealings. Evolution of international law. International law is of very recent origin. The development of international law is the result of development of international relations. In his famous book International Law, Professor T.J. Lawrence, who has made a special study of its developments, has divided it into three periods. The first period begins with the origin of European civilization and lasts till the beginning of the Roman Empire. The second period begins from the Roman Empire and lasts till Reformation. The third extends from 1648 up to the present time. First period. India was aware of much of international law when the rest of the world was in uncivilized stage. For example, in the post-Vedic period, there existed certain rules according to which wars were declared and waged, treaties were announced, alliances were negotiated, and ambassadors were accredited. Ambassadors were not to be killed because it were they who gave the messages of their rulers to the foreign ruler. They were never convicted whether disclosed good messages or bad ones. Indian rulers observed a regular code of war. References have been made to these rules in the Mahabharata and in other books of ancient times. In the 3rd century BC, Rhodes, a famous city of Greece, became a very great trade center. The traders of Rhodes started following certain rules which later on began to be observed by other states of Greece. These rules are known as Maritime Code. They also recognized the law of mankind, which established a system of a protection of invoice, obligation of alliances, and sanctity of treaties. With the dawn of Roman Empire, they also developed a system for dealings with the alien states. This system is known as Jus Gentium, which means law of nations. The Jus Gentium is the real contribution of Rome in the development of international law. The Jus Gentium was a code of rules applied to the dealings with the citizens of different nations. This code of rules is very similar to the international law. Second period, there was no development in international law so long as the Roman Empire existed. The theory of common superior over all political units of the world was very popular. After the fall of Roman Empire, feudal states emerged. The feudal rulers protested against the supremacy of the church. The concept of territorially independent states was brought in which the advent of the feudal system. The supremacy of Pope was questioned. Pope's interference in the internal matters of the states annoyed the European rulers. The rulers abolished the authority of Pope and organized nation states. Wars were declared by these nation states against one another. The church laid stress to carry out these wars in human ways. Ayala, the judge of Spanish military court, Mr. Gentile, a prominent figure of Italy, and other famous jurists of Spain and political thinkers belonging to the latter half of the 16th century maintained that the dealings between different states should be regulated by law of reason. The states should observe the law of reason while dealing with other states on international level. Third period. The third period extends from the date of Reformation up to the present time. Hugo Goethe's book on the law of war and peace, 1625, is a notable contribution of this period. This book reflects upon the cruelty of wars fought in 16th and 17th centuries. Hugo Grotius, the Dutch scholar, formulated the doctrine of international law and analyzed international practice in his book. He laid stress on two fundamental doctrines. Number one, all states are equally sovereign and independent. Number two, the jurisdiction of the state is absolute over its entire area. His book on the law of war and peace deals in detail with the international laws of war and peace. References have been made to these laws of war and peace in the Peace Westphalia, 1648, which ended 30 years of war. International law of which we are aware in modern times is essentially the product of this period. Wheaton and Oppenheim are more prominent among the political thinkers who have expressed their views on international law. Scope and essential of international law. The scope of international law is extended to all the free and independent nations. According to international law, all the states, whether they are small or big, enjoy the same status. No principle of law, said Chief Justice Marshall, is universally acknowledged than the perfect equality of nations. Russia and Geneva have equal rights. It results from the equality that no one can rightfully impose a rule on others. The more comprehensive division of essential of international law are: number one, laws governing states in times of peace. Laws of peace include the rights and obligations concerning independence and equality of the states. They also include maritime code and navigation laws. They are the rules of intercourse of the states. They include the rights and duties of officials attached to foreign offices. They include privileges and facilities of diplomatic representatives, organizations and procedure in international conferences, and nature and method of treaty making. Number two, law governing states in times of war. The rules of war include the declaration of war, the classification of wars, laws and customs of war on land, sea, and air, the after effects of war, the dealings with war prisoners. According to the laws, it is quite unconventional to use poisonous gases and bacteria in the warfare and to bombard the civil areas. These rules prohibit the states engaged in war from seeking foreign military assistance and from mining the ports. Number 3. Laws governing states in the relation of neutrality. The laws of neutrality embrace the duties of neutral states to belligerent states, neutral trade, commerce, contraband, and blockades. The basic question, what is international law, embodies several other questions that need to be answered in order to understand that what we are examining. What does international law do? How does it work? Is it effective in what it does? And ultimately, what can we expect from it? We will discuss answer of all these questions in our upcoming videos. So click on the bell icon and also subscribe our channel. Thanks for watching Think Critically.